And welcome back to Historical. Today, we're going to talk about George Stinney. I don't know if you're familiar with George Stinney, who he was, and what took place, but I promise you, by the end of this episode, you'll know. Imagine being 14 years old, still small enough that when you sit in a chair, your feet barely touch the floor. Now imagine that chair is the electric chair. In 1944, the state of South Carolina executed a boy named George Stinney. He weighed around 90 pounds. Witnesses later said he was so small they had to place a Bible on the seat so that the straps would hold him in place. His trial lasted all of 2 hours. The jury deliberated for only 10 minutes, and 75 years later, a judge would rule something very chilling. The trial that killed him should have never happened. This is the story of George Stinney, a boy who was arrested, convicted, and executed in just 83 days. To understand this story, you have to understand the world that it happened in. The place was South Carolina, 1944. It was a small mill town surrounded by pine forest and railroad tracks. It was the kind of place where everyone knew each other, where the lumber mill dominated the local economy, but it was also a place divided by something deeper than money. It was divided by law. In 1944, the American South still lived under the system known as Jim Crow. And Jim Crow laws created a rigid racial hierarchy enforced through both custom and legislation. Black Americans and white Americans lived in almost completely separate worlds. Different schools, living in different neighborhoods. They had different hospitals, different entrances to public buildings. Even drinking water fountains were segregated. The idea behind Jim Crow wasn't subtle. It was a system designed to maintain racial control and social dominance. And nowhere was that imbalance more dangerous than inside the criminal justice system. In many Southern courtrooms at the time, Black defendants almost never faced juries that looked like them. They faced all white juries. And when the alleged victims were white, the pressure to produce a conviction could become overwhelming. Sometimes the verdict seemed decided before the trial even began. That was the world George Stinney was born into. He lived on the black side of town, separated from the white neighborhoods by railroad tracks, a physical boundary that symbolized something much larger. And George was just a 14-year-old boy. He was quiet. He was very small for his age. And by most accounts, he was pretty shy. He lived with his parents and siblings in a modest house near the tracks. To the people who knew him, he was just another kid in the small town. But in March of 1944, that town would suddenly become the center of a tragedy that still echoes today. And what happened was on March 23rd, 1944, two girls set out on their bicycles. They were going for a little drive. Their names were Betty June Binnicker and Mary Emma Taines. Betty was 11 and Mary was 7. And for them, it was just a normal afternoon. The kind of quiet spring day where children rode their bikes through the town looking for adventure. The girls that day were searching for maypops. And maypops are a wild fruit that grows in that region of South Carolina. At some point during the afternoon, they encountered George Stinney and his sister near their home. The girls asked if they knew where they could find maypops, and George replied he didn't know. The conversation lasted only minutes. Then the girls rode away on their bicycles. It seemed like nothing, a normal interaction. Just a small interaction between kids in a small town. But it would later become the last confirmed sighting of the two girls alive. As evening approached that night, the girls still hadn't returned home. And at first their families assumed they were simply playing somewhere. But as the hours passed, worry began to set in. And by nightfall, the town realized something was very wrong here. So they searched areas, woods, everywhere. Search parties formed. Neighbors, police officers, and volunteers began combing the area. Everyone was looking for two missing children. The next morning, the search ended in the worst possible way. The bodies of Betty June Binnicker and Mary Emma Thames were discovered in a shallow ditch filled with water. These two young girls had been brutally beaten. Investigators believe the weapon may have been a heavy blunt object, possibly railroad spikes that were found nearby by the railroad tracks. This crime completely shocked the town. Two young girls murdered. And in a quiet community where violent crime was just rare. And almost immediately, the attention turned toward the last person known to have spoken with them. A 14-year-old boy named George Stinney. So police, they located George pretty quick. He was arrested and taken into custody. Again, he was only 14 years old. What happened next would become one of the most controversial parts of the entire case. George was interrogated by police, but there were no parents present, no lawyers present, no written record of the questioning, no audio recording, and no signed confession. Authorities later claimed the boy confessed, but the confession existed only in the statements of the officers who questioned him. And even today, the subject of confessions remains one of the most troubling areas in all of criminal justice. Modern research has shown that false confessions do happen, especially among juveniles. Children and teenagers are far more vulnerable during interrogations. They are more likely to feel intimidated by the authority figures, more likely to become confused under pressure, and more likely to say what they believe investigators want to hear. Today, many departments record interrogations precisely because of this risk. But in 1944, those protections did not exist. All the public had was the word of the police. And within days, the narrative was set. The case was closed. The boy had confessed. And the town believed they had their killer. Once the arrest was made, the machinery of the legal system moved with shocking speed. In cases like this, in the Jim Crow South, the goal was not to have a careful investigation, not at all. The goal was simply resolution. As the town, they just wanted answers. They don't care who paid the price or anything like that. The town wanted someone held responsible. And once George Stinney became the suspect, the investigation largely stopped looking anywhere else. Authorities stated that George confessed to the crime during police questioning. But there was a serious problem with that claim. First, there is no written confession, no transcripts, no recording, and no neutral witness present during the interrogation. There is also no signed statement from George himself. Everything we know about this alleged confession comes from the police officers who conducted the questioning. Seems convenient. And remember, this was a 14-year-old boy being interrogated alone. No parent in the room with him. No lawyer was in the room with him. No one whose job it was to protect his rights was in that room with him. Today, we understand far more about how interrogations can influence suspects. Psychologists and legal scholars have documented how easily false confessions can occur, particularly with young people. Children are especially vulnerable. They want to escape the stress of the questioning. They want authority figures to approve of them. And they may not fully understand the consequences of what they say. In some cases, investigators unintentionally guide suspects towards certain answers. Unintentionally, intentionally, we'll leave that up for you to decide, but sometimes it comes through suggestions, sometimes through pressure, sometimes through sheer exhaustion. Today, many police departments record interrogations specifically because of this problem. But in 1944, none of those safeguards existed. None. All the public heard was a simple statement. The boy confessed. And for many people in the town, that was enough. The speed at which the case moved through the system is almost unbelievable. George was arrested in late March. His trial began April 24th, 1944, only a month later. In modern courts, murder cases often take months or years before reaching trial. Investigators gather evidence, attorneys prepare defenses, both sides have experts analyze forensic details. The trial of George Stinney lasted only a few hours. Just one single day in court, not even the full day. The prosecution presented the basic outline of the case. 2 girls disappeared. George was the last person to have known to see them alive and speak to them. And the police claimed he had confessed. That was essentially the core of the prosecution's argument. There was no physical evidence tying George to the crime, no fingerprints, no forensic analysis, no confirmed murder weapon, and perhaps most sinking of all, the defense presented almost nothing. George's court-appointed attorney was named Charles Plowden. He was a local tax commissioner running for political office. That seems convenient. Historians have long debated whether he had the time, resources, or motivation to mount a real defense. What we do know is this. He called no witnesses. None. Not one. Not even George's sister, who was there. She could have testified about what happened that afternoon, but she never took the stand. George's parents had fled town after receiving threats from white residents. They were not present at the trial. 0 expert testimony was introduced, and no meaningful cross-examination of the prosecution's case occurred. In effect, the defense barely challenged the accusations against George. The jury that would decide George's fate consisted of 12 white men. And this was very common in the South at the time. Black citizens were routinely excluded from jury service. So when black defendants entered the courtroom, they were judged by juries that did not reflect their community. In cases involving white victims and black defendants, the social pressure on those juries could be enormous. The trial proceeded very quickly. Witnesses spoke, arguments were made, and when the jury left the courtroom to deliberate, they were gone for about 10 minutes. 10 minutes. That's it. 10 minutes is how long it took for a jury to decide the fate of a 14-year-old boy. When they returned, the verdict was simple: guilty. And the judge sentenced George Stinney to death. And because of the speed of the trial, there was almost no time for appeals. And that was probably by design. No long legal battle, no extended reviews. The system moved forward with chilling efficiency. Within weeks, the execution date was set, June 16th, 1944. Less than 3 months after his arrest. George Stinney would become the youngest person executed in the United States in the entire 20th century. He was 14 years old. That's it, 14. On the morning of the execution, George was taken to the South Carolina State Penitentiary. Witness described him as small and frightened. He had spent weeks alone in a jail cell, separated from his family, separated from the world. When the time came, guards escorted him into the execution chamber. At the center of the room sat the electric chair. It had been designed for adult men, and George only weighed around 90 pounds. He was barely tall enough for the restraints to hold him properly. He was strapped in, the mask was lowered over his face, and then the switch was thrown. When the electricity surged through the chair, something went wrong. The mask reportedly slipped off his face. Witnesses said they could see his expression during the execution. Imagine that. Whew. Moments later, George Stinney was dead. He was only 14 years old. For the town, the case was closed. 2 girls had been murdered. Someone had been executed. The system had done its job. Or at least, that's what people believed at the time. But history has a strange way of revisiting the past. And sometimes, the questions that were ignored in one generation return to haunt the next. After the execution, the case of George Stinney slowly disappeared from public attention. In many ways, that was typical. Cases like this were not unusual in the Jim Crow South. Black defendants were convicted by all-white juries, trials moved quickly, appeals were very rare, and executions followed. And once the sentence had been carried out, the system simply moved on. The official story was simple. A boy had committed a crime, the court handled it, and justice had been served. And for decades, that version even remained largely quite unquestioned. That's how it went. But the families involved never forget. Not the families of the 2 girls, and not the family of George Stinney. His relatives always maintained the same thing. George did not commit these murders, they said. They believed the investigation had rushed to judgment, that the trial had been unfair, and that the system had failed a 14-year-old boy. But for many years, there was little they could do. The legal system had closed the case. George was gone, and history had moved on. But then, decades later, something unexpected happened. Attorneys and historians began taking a much closer look at the case. They started examining the old records, the court transcripts, the police statements, And as they dug deeper, serious problems began to emerge. The alleged confession had never been documented. There was zero physical evidence. The trial lasted a few hours. The defense called no witness. Even basic legal safeguards that we consider standard today had been completely absent. In many ways, the case looked less like a careful search for truth and more like a system rushing to produce a result. Eventually, the case reached a South Carolina judge for review, and this was in 2014, 75 years after George Stinney had been executed. And after reviewing the evidence, or rather, I should say the lack of evidence, the judge reached a striking conclusion. He decided George Stinney had been denied due process. The court ruled that the original trial had been fundamentally unfair. Key witnesses had never testified. The defense had failed to challenge the prosecutor's case, and the alleged confession had never been properly documented. So the conviction of George Stinney was vacated. Legally speaking, that means the court erased the guilty verdict. But 75 years after his execution, it's pretty sad. But that ruling raises a difficult question. What does justice mean when it arrives 70 years too late? I mean, what does that even do? The legal system corrected the record, and that's great. But it can't correct the outcome because George was executed. George Stinney never had the chance to grow up. He never had the chance to tell his story. He never had the chance to live the life that was taken from him at 14 years old. His family spent decades carrying the weight of that conviction. Decades living with the knowledge that the system had branded their son and brother a murderer. Even when the court finally acknowledged the injustice, George was still gone. Sometimes history forces us to confront a very uncomfortable truth. That justice delayed is not always justice denied. But sometimes, justice delayed is simply too late. Cases like this force us to ask larger questions about the systems we build. How much pressure can a community place on an investigator before objectivity begins to break down? How easily can fear, anger, or public outrage push a legal system toward speed instead of accuracy? And how many other cases from that era were decided in similar ways? Cases that history has never revisited. We often think of the justice system as something solid, something reliable, something that's immune from the pressures of society. But history shows us something very different. The justice system is built by people. And like any human institution, it can fail. In the end, the story of George Stinney is not just about a courtroom. It's about a moment in American history. A moment where fear, race, and the demand for quick answers collided inside a legal system. And that system was supposed to protect the innocent. A moment when a 14-year-old boy sat in a courtroom surrounded by adults who held the power to decide his fate. And a moment when the jury took just 10 minutes to make a decision that would end a child's life. 70 years later, the court admitted the truth. The trial had been wrong. But by then, The electric chair had already been switched off. History isn't only written in textbooks. Sometimes it's written in courtrooms. Sometimes it's written in the verdict. And sometimes it's written in the silence that follows a mistake that no one can undo. This episode was built from historical documentation. And as usual, a full source list and reading list is available in the show notes. I am historical, and I tell history stories that refuse to be forgotten.